Let's move to Miles in Mason, who asks the question, I submitted my offer to the seller and she told me that she would sign the offer when she received it. She then called me back to tell me she went with another buyer. Don't I have a contract? That's his question. Don't I have a contract?
Well, if that is a little bit more complicated than it seems.
Okay.
Because, first of all, in real estate, you have a contract when two parties sign a real estate purchase agreement or any other document that relates to real estate for any contingency to that real estate, I don't know, transaction has to be a year or more, should be in writing. So anything involving real estate where the transaction is going to be a year or more should be in writing, okay? With regards to this transaction, you could make an argument if the two of them have enough information going back and forth in emails or documented conversations that basically say, I agree, and the only thing you have to do now is send it to me and I'll sign it. This is more offer and acceptance, real contract law, less real estate law. Then her obligation is to sign it because they had an agreement. If I do this and you do that, I will sign it. Okay, that's one problem. But here's the thing, it's real estate. And we don't know what was really said in this situation. What if she said, I'll consider it? Send it, I'll consider it. Well, that's different than send it and I will sign it. So we really don't know what happened there. And everybody has a different reality. And a buyer in this market really wants a home, so we understand that. But I don't think that it's going to be very difficult. What are you going to do? Try to go to court to enforce a contract? What's this person's name again?
Miles.
Miles. Unless you have something in writing that says, I agree to everything that you say, Miles, just send it over and I'll sign it.
Then he doesn't have a contract.
If there's no changes to any of those agreed upon terms, then yes, they would have a contract. But if it's verbal, and it's not going to be easy to enforce. So the real question is, when do you have a purchase agreement between a buyer and a seller that's valid? When the parties sign it.
Right.
That's really, the best way to gauge if you have a valid purchase agreement. It can fall apart later because we were talking about contingencies. It could fall apart because of an inspection. It can fall apart because the marketability of the title is not there. It can fall apart because of so many different municipal code issues. There's so many things. But until the parties agree that the agreement is no longer valid, or that there's an event that triggers the termination of that contract, it's a valid contract because it's signed. What Miles is asking for is too difficult. I would never take a case like that.
I've had that personally happen to me before, where it was just verbal speaking to a seller over the phone, and I make my verbal offer and they say, that sounds great. Yeah, let's do it. Let's do this. And then I draft the purchase agreement and get it to them just within a few hours. And then I don't hear anything from them. And it's not usually, this lady's actually quite polite. It's usually me calling them saying, hey, and they're like, oh, I changed my mind. So even though, but I've never even thought to call you to pursue anything on that. I just was like, just irritated by it.
Yeah. I mean, it's definitely irritating.
It's only been one time where someone said that. So, and I think, but to me, it was like, when someone asks you, hey, what are you doing? You want to go get coffee? And you're like, yeah, that sounds good. But then later you're like, oh, I'm washing my hair.
I might not be saying I'm washing my hair. I know what you're saying.
On the phone, you don't know how to say no. Type of
but here's the thing. I think that question relates to the fact that he actually had something in writing.
Perhaps because he said, I submitted my offer to the seller. That makes me think like he emailed the purchase agreement and etc. And she said, I'll sign it when received.
Right.
So there's something more meaty than that.
But it's not, to me, it's not enough like to go to court with, right?
Sure.
Unless, I'll just change the fact pattern just a little bit. You have emails going back and forth,
Mhm.
and then the seller, potential seller says, everything that we've talked about, it's 100%. I have no further changes. Send me over the paperwork and I'll sign it.
Sure.
Now I believe you have an agreement.
Sure.
Okay.
It'd have to be
not the
very
case I
cut and
wanted to.
dry. Right.
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 But you know, there's some valid arguments that they have an agreement. And the thing is, there's something called, I have an article, if you go on provenresource.com, called, you know, it deals with letters of intent. What is your
Okay.
intention? And a lot of people, you know, a lot of people think these communications are innocent and you don't have to, you know, abide by them. But if you put something in writing, even if it's a letter of intent, which is just like, hey, maybe I'll buy this, whatever, the more specific you get in your letter of intent, the more concrete you get with your terms and dates, okay?
Yes.
Things occurring, it actually can be construed as a contract,
Okay.
okay? And
Mhm.
I've been in court on those and we have prevailed. So you do need to be aware that, you know, your words have meaning. And
Yes.
your actions have meaning, even in real estate, which 99.999% of the time requires written documentation
And
that is
even your text messages are submissible, correct? Like if you
or
are
they're
texting,
admissible.
admissible, excuse
Right.
me. So
Okay.
not even just an email. If you're texting back and forth, that could be
Right, we
put
can
together,
use
right?
that, and we have used that. It's
Okay.
corroborating evidence. But here's the thing: on so many things, like let's say you have let's say he sends in a signed document. She never signed. The seller never signs it. Okay, but she says, let's get the appraisal. Let's do this. Let's do all this. Let's do the home, and but she's never signed it. Okay, that's an exception to what we call the statute of frauds, which requires everything to be in writing. That's an exception. It's called partial performance.
Mm-hmm.
So if the party's actions appear and are reasonably appear that the parties are going through the motions of the contract, pardon me, it's a contract.
Okay. Good to know. Good. Well, thank you, Miles and Mason. That was